Hi everybody, my name is Catherine Del Rosario. I'm an immigration attorney with McEntee Law Group. We are based here in Chicago, Illinois, and we work on exclusively immigration matters. Today's webinar is on employment-based options for DACA recipients. With DACA under relentless attack, it's important for DACA recipients to assess all of their options with immigration. And I think relief for undocumented individuals usually focuses on humanitarian or family-based options, but today we wanted to give a brief overview of employment-based options and common issues that DACA recipients will face. As a reminder, this is a presentation that's meant for general information purposes only. It should not be taken as specific legal advice for you. You should always consult with an experienced immigration attorney, especially on this topic. Please note that all timelines that are provided today are estimates as of the date of this presentation, June 26, 2024. And these times are subject to change depending on the government's workload and the specific facts of your case. So today we're going to be talking about temporary immigration options that are employment-based, as well as permanent immigration options, namely the labor certification, which is a huge part of the green card process if you're going to be sponsored by your employer. We'll talk about the eligibility requirements for adjustment of status or a green card application, as well as consular processing, which is the immigrant visa process abroad. And then lastly, we are going to touch on the recent executive action that was announced on the 18th for college graduates and those who have a job offer. I'll also leave time at the end for questions, of course. Okay, so to start, I wanted to focus on the H-1B visa because it's one of the most common temporary employment-based status. It's where a U.S. employer can hire a foreign-born worker for a professional level job that requires at least a bachelor's degree in a particular field. So some examples of what's called a specialty occupation, this is a key word for this type of visa, would include architecture, engineering, math, the sciences, medicine and health, education, a variety of business specialties, accounting, law, theology, and the arts. Every year, there is a cap on the number of H-1B visas that are available. It's capped at 65,000, and there's an additional 20,000 visas for people who have earned a master's degree inside the U.S. There are also certain employers that are exempt from this cap. So if you were to get a job with an institution of higher education, a nonprofit that collaborates with that institution, or a government research program or nonprofit research program, those entities can hire H-1B workers any time of the year, and they don't have to enter that annual cap. Some things to note about the H-1B visa is that it is dual intent, meaning it is a temporary visa that does allow you to also pursue permanent residence or a green card at the same time. The visa is available in 3-year periods with a maximum of 6 years. Now, there are certain individuals who may reach a certain stage in their green card process that can extend their H-1B beyond that normal 6 years. In order to be eligible for the H-1B, there are a few criteria. First is the degree. An important requirement of the H-1B is that the job and the degree match. So for example, if you are going to get a job as a software developer, you should probably have a degree in computer science, information technology, or computer engineering, something of that sort, something that's directly related to that role. You must have a job offer or a current position in a specialty occupation from an employer that can sponsor you for the H-1B. So this would be a U.S. employer. You must have an initial lawful entry. So you must have entered the U.S. through a port of entry with either a tourist visa or some other temporary status. And then you must have less than 6 months of unlawful presence, or ULP. So unlawful presence starts once someone turns 18 years old. You can't accrue or collect unlawful presence before that age. And if you have been granted DACA, then the start of your DACA period stops the clock on that unlawful presence. Now, where many DACA recipients will run into issues is on that lawful entry and unlawful presence criteria. So if they don't meet all of those requirements, they may have to temporarily leave the United States in order to complete the H-1B process. And one reason for that is because DACA, while it does allow you to live and work here in the United States, it does grant you lawful presence, it doesn't grant you status. So the way that the process works is your employer would file an H-1B petition with USCIS, which is the agency that grants many immigration benefits, while you are living here. And then when that petition is approved, you may have to leave the United States for consular processing. So consular processing includes submission of the non-immigrant visa application and then attendance at a visa interview at an embassy abroad, typically your home country. And the wait times to get a visa appointment can vary from consulate to consulate. So once you attend and if your visa is granted, then you would re-enter the US on that H-1B visa. And notably, you would now have a lawful valid entry. You can consider obtaining advanced parole, which is like a travel permit to leave the US temporarily and return, so that in the event that your H-1B visa is rejected, you can still come back. And we'll talk a little bit about advanced parole. Advanced parole is a one-time travel permission, and it's available to DACA recipients based on certain criteria. There are 3 major categories, and I'm giving some examples of the types of events that may qualify you for this advanced parole. The first category is humanitarian. This is typically where I see most of my clients who are seeking advanced parole fall under. So they may need to attend a funeral, visit a sick family member, or retrieve medical supplies. And we've been successful in obtaining advanced parole for those visiting like immediate relatives, but also extended family members. You can also qualify for educational reasons. So if you'd like to participate in a study abroad program, or you need to travel for a research project. And then finally, employment. So if you need to attend a job interview, client meeting, conference, or other work-related travel. I would note that returning to the United States on DACA advanced parole is considered just that, parole. It's not a lawful admission. If you're wondering if there are exceptions to that unlawful presence requirement, there is an opportunity to still get this visa if you can obtain a waiver. We commonly refer to this as the D3 waiver, and it excuses certain grounds of inadmissibility, including unlawful presence. And it would allow a DACA recipient that's otherwise eligible for the H-1B to attend their visa interview abroad and then re-enter once that visa is granted. It can help DACA recipients who do have more than that 180 days of unlawful presence, because otherwise, if they were to leave without that waiver, they would trigger either a 3 or 10-year bar, which is terrifying for anyone who's considering this. Like, the moment that you step outside, you can't come back for 3 or 10 years. So it's essential that if you are facing a ground of inadmissibility, that you consider this waiver. And a ground of inadmissibility is basically a reason that someone would not be allowed to enter the United States. There has been a recent announcement of an executive action regarding this waiver, and we're going to return to that. It's super exciting and important, so we want to give it its time towards the end of this presentation. So let's say that you have been successful in obtaining the H-1B visa. You're now here working in your job. So DACA recipients who have obtained that visa can eventually adjust to lawful permanent resident status, or they can get their green card. Again, I noted in the beginning that H-1B is a dual intent visa, and that's why H-1B is so great, because you can, transition to a more permanent status without risking or putting your H-1B at risk. So while you're on this H-1B, your job may choose to sponsor you for an employment-based green card. This is usually going to be in the EB2 or EB3 category, and we'll talk about what that means. These are the list of employment-based categories that range from, I guess, the most extraordinary to the least, and then there are some special categories here. I'm going to focus on EB2 and EB3 because these are the most common employment-based categories. So EB2 what that means is that the job that you're being hired for requires an advanced degree, or that you have exceptional ability. And then EB3 is where the job requires at least a bachelor's degree. For EB2, the job can also require a bachelor's and 5 years of experience, and that is the equivalent of an advanced degree. But anything lower than that, anything lower than a bachelor's and 5 is going to fall under EB3. So for most people who are pursuing an EB2 or EB3 green card, will be required to complete the labor certification process, or we call this PERM. When I was talking about the H-1B, the focus there was that you were going to be working in a specialty occupation, so fairly high level, and that you have the degree to match. Now with an employment-based green card, the options are wider. There's more flexibility in the type of roles, because almost all full-time non-temporary jobs may qualify. So in addition to all of those specialty occupations we named, we've also completed this process for cooks, chefs, caretakers, nannies, things like that. The goal is different with the green card. It's to protect U.S. workers. So we have to show that there aren't any that are able, willing, and qualified and available to accept the job at the prevailing wage, so at the rate in the area of intended employment. This is an important step in a long process towards a green card. And I would note that your employer is responsible for all of the costs at this first stage. I have the whole process kind of laid out in 4 boxes here, but it actually takes place over, I would say, 2.5 to 3 years. And the most important part arguably being the beginning, where your attorney, your employer, and you sit down and talk about what job they're sponsoring you for and what is required of that position. Because we have to show that you had all those skills, you possess all those skills, or the degree that they require prior to working for them. And then we present that job next to the Department of Labor. We file what's called a prevailing wage request, where the Department of Labor takes a look at it, and then they tell us how to categorize that job and how much that job should be paid in the location that you're going to be working. That process alone can take about 6 to 7 months. If the wage comes back and it looks good and your employer accepts it, then we move on to recruitment. This is maybe one of the toughest parts of the process, where it's a test of the labor market, where we are required to post advertisements for this job. And the Department of Labor requires certain methods, such as Sunday newspaper, state workforce agency, and then there are additional methods that we have a little more flexibility in, such as job search website, company website. Employers also required to put a physical posting at their office. Recruitment can last anywhere from 2 to 6 months. And then the final step in this first stage is the filing of the labor certification. So this is now us telling the Department of Labor, hey, we did recruitment properly, there's no US workers available, and you should agree with us. That labor certification is taking more than a year to be processed. We're at kind of an all-time high in terms of processing times. And these applications can also be audited, meaning the Department of Labor can ask for a lot more information. They can ask you to provide all the proof that recruitment was done properly, that the employee, you, were not involved in that process, because that would kind of compromise the integrity of the whole thing. And audits can certainly push back the timeline, normally about 6 months. From here, if the Department of Labor certifies the labor certification, it means that they agreed with us that there was no US worker that's available. And now we can turn our eyes to immigration, the immigration agencies. And your employer will file what's called an I-140 petition on your behalf. This is filed with USCIS inside the United States. It can be premium processed, meaning you can pay a bit extra to get a decision quickly, like within about 2 weeks. What this petition means is now we're talking to immigration, and your employer is saying, hey, the Department of Labor agrees no US worker available. Well, we have someone, we've identified someone, and it's this employee. And then what happens after that depends a lot on you. So it's where you are in the world, it's whether you, what status you hold now, if you're eligible to adjust, meaning eligible to apply for your green card here, or do you have to go abroad? If you're here, you'd file your green card application with USCIS, and that will include applications for a work and travel permit. And it will also depend on where you're from and what category you are filing under, because there are certain countries that are subject to very long visa wait times. So in particular, Indian, Chinese, Filipino, and Mexican nationals have their own wait times, and then everybody else falls into another category. So there are a lot of factors involved in determining where and when you're going to complete this last stage. If you are not eligible to adjust your status, which is probably like what most DACA recipients, what position they're in, they will likely have to consular process, meaning the I-140 petition gets approved and then it gets sent to the embassy in your home country, and you have to attend an interview there. And if it's approved, then you re-enter the United States as a permanent resident, so as a green card holder. Now let's talk about who can file their green cards in the United States and who can't, and then how we can overcome that. So generally, under our immigration law, I'm gonna be saying a lot of numbers and letters, and I'm gonna try not to, because I understand our audience may not be lawyers. I hope they're not, actually. I hope this is helpful for like normal people, everyday people. So I'll try to stay away from abbreviations and numbers, but I'm sorry if it comes out of my mouth anyway. Okay, so under our immigration laws, individuals who were inspected and admitted or paroled may get their green card in the United States or adjust status. But there are certain bars, I can't avoid this, 245C, that's like a section of the law, and there are like barriers to getting a green card listed under that part of the law. And these are the most common ones that DACA recipients would face. So they may have unlawful immigration status on the date they filed their adjustment of status application, which would be the case for a DACA recipient because DACA is not status. They may have failed to continuously maintain lawful status since entering the US, engaged in unauthorized employment prior to filing the green card application. So if you worked before you got DACA, this would be you, if you are seeking an employment-based green card while not in lawful non-immigrant status, and if you violated the terms of your non-immigrant visa or engaged in unauthorized employment. If you are a DACA recipient, most likely you are facing one of these bars. And so let's talk about how to overcome that. There's another provision of the law, 245I, which allows those who enter the country without inspection, or those who have failed to maintain their status, or those who have worked without authorization, to adjust their status anyway. And so to qualify for adjustment of status under this part of the law, a bunch of things need to be true. So there must have been a visa petition or a labor certification that was approvable when it was filed on or before this date. This is an important date, April 30, 2001. The principal beneficiary was physically present in the US on December 21st, 2000, if the petition was filed between this time period, January 15, 1998 and April 30, 2001. There must be an immigrant visa immediately available to them. They must be admissible or allowed to enter the United States or otherwise eligible for a waiver. You have to pay a $1,000 penalty fee in addition to all the other green card fees. You must be physically present in the US at the time you file your green card application, and you must warrant a favorable exercise of discretion. I would note that you may not be the person that somebody filed a petition for, but if you were like the spouse or child of the person who did get a petition filed, you may be able to benefit from this part of the law. And it also allows someone who's no longer a child or no longer a spouse of that principal beneficiary to still be eligible. So it's not a common thing, but we always ask about it. We always ask, do your parents have status? Did anyone file anything for them? And it's always a great day when someone says yes, and we can find that petition, and the date is before April 30, 2001. Because what this means is that you can file your green card application here without having to consular process. There's another part of the law, 245K, so another number and another letter, that allows those facing those barriers or those bars that we talked about to adjust status here. To qualify for this 245K exemption, you must be physically present in the US on the day that you file the green card application with a lawful admission, and you must not have committed the immigration violations for more than an aggregate period of 180 days max. So 180 days is measured from the most recent lawful admission, and DACA recipients may have a lawful entry, but they're likely to have other bars. So this is also rare, but it's possible. If you don't qualify under 245I or K, this is where we kind of go back to the first topic that we talked about, the temporary visas, to see if you can get a lawful entry that way. So we can consider H-1Bs, L visas, or TPS. I would note that L visas are also dual intent, so they allow you to be in this temporary status and also try for a green card. But the thing with L is that you have to have worked for a foreign company for at least a year, and then you're being transferred to a US entity. So you would have to be prepared to leave in that scenario and possibly work in your home country for a year. Or if you're from a country that has TPS, temporary protected status, available to them, that would be a great option to explore as well. Okay, so if we have determined that you cannot adjust status in the United States and you really do have to consular process, we have to think about what barriers you might face when you go abroad. The biggest one being the 3 and 10-year unlawful presence bars. So if you've been here without status for a long time, the moment that you leave and try to come back, an officer may tell you you can't for 3 years or for 10 years. And this is if you've had more than 180 days of unlawful presence. So there's another waiver available here. It's called the I-601 waiver. But the tough thing for DACA recipients is that for this type of waiver, you need to prove extreme hardship to a qualifying relative. And that qualifying relative needs to be a US citizen or green card holder, parent, or spouse. And I would think that if you had a US citizen spouse, at the very least, you'd be going maybe the family route anyway, and not the employment-based. But I guess theoretically it's possible that your job is sponsoring you for the green card, but this waiver is hinging on a relative. And now, like, the very, very exciting part of our talk here is about this recent executive action. On the 18th, just this month, the Biden-Harris administration announced actions to ease the non-immigrant visa process for people who have graduated from a US college and have a job offer. So this is incredible. It would allow dreamers and others to more quickly receive their non-immigrant work visa if they're eligible for the visa. So the idea is that consular officers will now be given clearer guidance about when they should recommend expedited processing of the D3 waiver, which we talked about earlier. So just to review, let's take the H-1B, for example. If your job wants to sponsor you for the H-1B, they're gonna first make sure that you're eligible. They're gonna check your degree, match it up to the job, promise to pay you the wage in that location, and they're gonna file this petition here in the United States. That petition has to be approved, and then you submit a non-immigrant visa application and you make an appointment to go to your consulate abroad for this interview. And so applicants who are denied or otherwise would be denied for the visa because of some inadmissibility or ineligibility will be notified by the officer of the reason and whether they can apply for the waiver. And as a reminder, the D3 waiver does cover unlawful presence, which for DACA recipients is probably the most common reason why they wouldn't qualify. And so these waiver requests are ultimately decided by the Department of Homeland Security, but it's based on a recommendation by the Department of State, which is the consulate. So the upcoming updates to the FAM, which is the Foreign Affairs Manual, which is the consular officer's guide to everything they do and how they make decisions. These new updates are going to clarify when a consular officer should recommend that Homeland Security grant the waiver. And it should be consistent with the waiver process that's already available under our current laws. I think it's important to note that this executive action is not going to be granting any new benefits to DACA recipients, and it's also not limited to just DACA recipients. So this new guidance will also encourage consular officers to consider recommending expedited review of waiver requests at the same time as the non-immigrant visa application. Also, again, consistent with existing guidance. So I think one thing that's important to note here is that the framework for this process exists, and there is some guidance in it. I was looking at it earlier today. There's some criteria that the officer should consider, like if you have multiple criminal offenses, or if it's in like the national interest to allow you to work, or the severity of your immigration violation or your role in that violation. These are all things to keep in mind, but it sounds like this new guidance is going to make it even more clear. And so We've been given the timeline that the specifics of this guidance is supposed to be released within the next 30 days. I'm especially excited for the recommendation for expedited review, because otherwise D3 waivers can take months. So that means for months you're outside the United States. Whereas if the consular officer is doing expedited review, where they're being quick about it and deciding on it at the same time as your visa application, we're hoping that you can come back to the United States quickly. So the ultimate goal is that dreamers and others can receive their work visas more quickly if the Department of Homeland Security does approve that D3 waiver. As a DACA recipient, I'm often asked on job applications if I'll require employer sponsorship for an H-1B visa in the future. I'm unsure how to answer this. On one hand, I currently have work authorization through DACA, but I'm concerned that indicating I might need sponsorship could negatively impact my employment prospects. Can you provide guidance on how I should approach this question? This is tricky, because as a DACA recipient, you do not require sponsorship because you have an EAD. But if you want to move to a more permanent or more secure status like H-1B or a green card, you do kind of have to open up the conversation. I will say that most employers are not well versed in this area. A lot of attorneys are not well versed because it's kind of a rare situation where someone can meet all the requirements. But as the DACA program gets older and DACA recipients get their degrees, I think we're going to be seeing more and more of this. So I think it will require I don't even think this is legal advice. It's more just advice that it will require some relationship building probably on your part to open up the conversation and be candid with your employer, because all the processes that we talked about are very much employer driven. We require their participation in it. And so we'll have to talk about it at some point together. And they may want to seek counsel to walk them through this, which I definitely recommend. But I guess there wasn't a straightforward answer to your question. You can answer it the way that you have been, but in order to open up your options, you do kind of have to confront the subject. Just to clarify, a D3 waiver waives the 245C bars. Yes. There are more bars than that, but I pulled the ones that I thought were most common for DACA recipients. What about the EB-2 program? That's also, everything we talked about will also apply to that. So even if someone is able to obtain the EB-2 NIW, but they're without, they were a DACA recipient, they will still have to go through these steps. The Biden-Harris administration recently announced actions to ease the non-immigrant visa process for U.S. college grads who have a job offer. Does this policy apply to any job offer, regardless of the field of study, or does the job need to be related to the graduate's field of study? Are there more details or specific criteria available about the policy? This is a great question. So, the employee will still have to be eligible for whatever visa they're going for, or whatever green card they're going for. So if it's the H-1B visa that you are applying for, then yes, your degree has to align with your job offer. If it's the L visa, so that intra-company transfer, you still have to meet the requirements of the L. The executive action that the administration has introduced is meant to ease the actual visa process. So actually getting that physical visa in your passport, because you're still otherwise not able to just change your status. You can't go from DACA to H-1B or DACA to L seamlessly in the United States. You're gonna have to go abroad, most likely. And so this executive action is supposed to make that process easier. There aren't more details yet about the criteria. Well, the criteria for the visa is still the same, but the guidance that's going to be provided to consular officers has not been released yet. The timeline that we've been given is 30 days. So 30 days from June 18th. If you're, I guess, wondering how to approach this as a DACA recipient, I recognize it might be scary to ask your job to enter into this process. We're happy to do consultations with you and assess your eligibility, what bars you're subject to or what bars you're facing, and give you kind of the tools to talk to your employer about it. But just know that ultimately it is your employer that will be driving this process, but there's no harm, and I think you'll be in a better position to kind of get this knowledge for yourself and know what you're facing. I can't stress enough how much your specific case, matters. There's so many factors. It's like this giant puzzle that we're trying to put together so that you can secure your status. And so I think this is my 5th reminder to make sure you're talking to an attorney to go through every single one of these factors, because we don't want to send anyone abroad without the proper documents they need to come back safely, whether that's getting the waiver or applying for DACA advanced parole as a backup. We want to make sure that you're protected and have the best options in front of you. An I-140 petition goes to a consulate, and then from there they approve the visa. Where does the D3 come in? Yeah, the I-140 petition gets filed and approved and decided in the United States, and then it gets sent to the National Visa Center, which for our purposes is just a website. And this is where you're going to fill out your immigrant visa application, the DS-260. You may also need to upload some documents and then you hit submit. And then from there, the case is going to go to an embassy abroad. You will then fulfill those requirements, scheduling an appointment, scheduling a medical exam if you need to, and then you attend the interview. And typically, okay, so I think we're combining 2 processes here. Let me take a step back. The I-140 is the immigrant petition. That's going to be a different process. So everything I've set up until now is accurate. You will need to consider another waiver option, because the D3 isn't going to apply here. If you're gonna go for an H-1B visa or an L, that's where the D3 waiver is gonna come into play. Similarly, the petition gets filed in the United States, and then case gets sent to the NVC again, but you'd fill out a non-immigrant visa application. Then it goes to the embassy where you schedule the appointment. No medical, forget the medical. You'll go to the appointment, and then the officer will assess if you're eligible. And if you're not, this is where they tell you that you'll need a waiver. And the particulars of this, we haven't seen yet. So I'm not sure if they're gonna issue you a denial and then tell you to apply. We're not sure if if you can apply on the spot. That's kind of the hope, but we will see. Those specific steps aren't clear yet, but that's at the interview is where the D3 will come up. Regarding advanced parole, how likely is it that USCIS will approve a petition to attend an international conference, like an engineering conference? I don't know how successful I would be with applying for the other criteria, such as humanitarian or employment. And I think it's the best one I can find for myself right now. So I think it's sort of widely accepted by practitioners that DACA advanced parole is generally approved. With that being said, you do have to fit under one of those criteria, and you have to provide the documentation. So if you are going to attend a conference, you should provide proof that you are invited, probably itinerary for the conference, any kind of, I would ask you for any credentials that you have that connect, that qualify you to attend, whether that's like your enrollment documents for a program, an internship, a fellowship, whatever connects you to that conference. On the other side of that, upon your return, I usually advise clients to try to get some proof that you did the thing that you were asking to do. So if you were gonna attend this conference, bring your badge or the program that you got or whatever materials that you received at that conference to show the officer when you come back that you did do that thing. Can a field-related degree work? If you're going for an H-1B, yes, your degree must be related to your field. I'm going to say that, under those 3 bases for parole, it doesn't say there that one of the reasons can be to attend your consular interview, but that is, in practice, that's been successful for many DACA recipients, that they're applying for advanced parole specifically to attend this interview. Heard from colleagues and in my own experience have seen that that's very possible as well. Well, I want to thank everyone for joining our webinar today. Contact us if you want your questions answered. Here's how you can get in touch. DACA is 12 now. The DACA program is 12. Presumably, so many recipients do have degrees and are receiving job offers and sadly have had to turn them down. So we really do encourage you to explore all your options, including employment-based, if you have DACA. And we're here to help. So thank you again, and we'll talk to you soon.